Good evening, everyone. Thank you so much for coming, and thank you for the community in Manchester for giving me the floor to talk about something very challenging, which is accountability and justice with regard to one of the worst crimes committed ever in history, where the Syrian regime is committing unprecedented war crimes and crimes against humanity, where international lawyers are in shock with the gravity of these crimes and the systematic torture and all the hideous details that we saw and we heard about. Since 2011, the Syrian regime systematically committed war crimes and crimes against humanity, and we have abundant evidence on that, whether from UN agencies or from the Commission of Inquiry, and with the help of Syrian NGOs and the help of civil society that are committed to document and work on these issues. These crimes, unfortunately, remains unpunished. We have very limited and few cases of criminals, of attempt to bring criminals to justice. Unfortunately, within the international criminal system, we have very limited options in Syria because of, with regard to the International Criminal Court, we don't, because of the political the lack of political will to refer the case, the Syria to the International Criminal Court. We can't access that for now because we all know because of the Russian and the Chinese veto. So we are left with an option called the universal jurisdiction or the extraterritorial jurisdiction that Muna touched on. So this way of justice, or this way of bringing accountability to the crimes committed in Syria, is based on the jurisdiction of third countries. So that's when we hear about cases being brought in front of the German or the Swedish or the French courts of war criminals that are in Syria, but some of their victims are resident, either refugees or other kind of residency. They are within the jurisdiction of these European countries. So far, we have few limited cases, as Mona said, but we also have some very successful cases, like the recent one where the head of the Air Force Intelligence, Jamil Hassan, there was an arrest warrant that was issued in Germany against him. So this is the accountability mechanism that Syrian lawyers and international lawyers are using for the with regard to war crimes and crimes against humanity committed in Syria. And I want to talk about another case other than the Jamil Hassan case. It's a case. It's with regard to Caesar photos. So there was another persecution that was initiated in France against with regard to. So they opened investigations on crimes against humanity and war crimes committed because of the evidence that we got from Caesar pictures, which I think is a very important development, because this means if we actually got to the point where there's a concrete case, it means that the French persecution could prove the chain of command and could actually persecute people at the highest levels in the Syrian regime, because we all know who the heads are, and it doesn't mean that these crimes, in particular crimes committed in prisons against detained people and against detained people, will not go unpunished, and we have a very strong evidence for that. There are other cases where there are other cases in the universal jurisdiction, like a case called Bab Amru. Bab Amru in Homs. I'm sure most of you know it. It's with regard to journalists that were targeted by the Syrian regime. Mona touched on something called the IIIM. It's a mechanism also created by the UN, and I think it's very important because we have a problem in the international criminal system that we need all evidence to be very concrete, and there are very strict information that they need in international courts to admit the cases in their courts. So the IIIM will reserve these files and will reserve the evidence that Syrian organizations and other organizations, international or civil society, are preserving in order for these cases to be used in the future when any legitimate international court or national court is established. I want to touch on the recent issue that we're having with regard to the death certificates. I want to talk a little bit about the legal implications of these death certificates, what it means to the legal status of these people. Under international law, these people are still considered to be forcibly disappeared. That's because the crime of forced disappearance is a continuous crime. So it means that it started from the minute the person disappeared till the minute the authority within the country reveals the information about this person, where they have been, what happened to them. They have the obligation, the state have an obligation to start an investigation, and they have the obligation to provide their families, the families of these people, with all the details with regard to the haythiyat, I don't know, like the whereabouts, what happened to them, how did they die. So when they say that they died with a heart attack, this doesn't mean anything in international law. Like the crime of forced disappearance still exists in the Syrian context under international law, because these death certificates, first of all, it doesn't mean that the Syrian regime fully obliged, fully disclosed and fully okay, I'm sorry, I can't think of the word, like fully I don't know, it doesn't matter, sorry. So it doesn't, the Syrian regime still have an obligation with regard to not considering these people as forcibly disappeared. So we still have this standing crime that we can use against the Syrian regime, and we have no idea why the regime is issuing these death certificates, but that it doesn't matter to us as international specialists, international law specialists, because if something within the Syrian legal system is legal for them, that does not mean that it's legal in the international law. So what they are doing within the system does not mean that in international law that we're not going to be able to do anything. That they issue these death certificates and that's it. The other thing is that the fact that we have a lot of reports that families are being forced to sign these death certificates or sign any other paper, even if it wasn't physical coercive measures. These death certificates cannot be used as evidence in court because it wasn't obtained in a normal manner. So because of the element of force, these evidence are not going to be able. They're not going to be used in within any international criminal court. Of course, I mean, I'm not gonna talk about the rights that detained people and forcibly disappeared people have in international law, because we all agree on the rights in international law and how they should be, but it's not gonna sound appropriate after what we heard and what we said, what we witnessed. So the families as well have a right to know, to know everything, not only the death certificates and the heart attack, like they died with a heart attack. And the other thing is, like, if let's say families did not attempt to obtain their right to know, this right is considered under international law to be a right of the society. We all, as Syrians, have a right to know what happened to the thousands of people. So I want to talk about something that in international law field we consider it to be positive. Maybe for you it's not going to be. But I talked at the beginning about the fact that we can't refer Syria to the International Criminal Court because of the need to the Security Council approval to refer the case, and then Russia and China will not allow that. The other thing is because Syria is not party to the Roma Statute, which means that the case cannot be referred to the ICC. But the very positive development that happened a couple of days ago is that within the ICC there's something called pre-trial chambers. Pre-trial chambers are the bodies that have the authority to decide or to advise the court if a case will be admitted in the court. So a couple of days ago, the pre-trial chambers ruled that the case of the Rohingya Muslims can be admitted within the International Criminal Court, although the crime itself was committed in the beginning of the crime, which is forced displacement. They forced the Rohingya Muslims to go from Myanmar to Bangladesh. But the fact that and Myanmar is not part of the ICC, so conventionally, like in principle, the case cannot be brought in front of the International Criminal Court. But because part of the crime, one element of the crime, which is crossing the border from Myanmar to Bangladesh, means that because Bangladesh is part of the Roma Statute and is a state party to the Roma Statute, so the case can be brought to the ICC. So this means in the Syrian context, because only like the example that I can think of now is the crime of forced displacement of people having to flee Syria, going either within Syria or outside Syria. But in this case, because Jordan is party to the ICC, it means that the case of forced displacement in Syria could potentially be brought in front of the ICC because Jordan is part of the Roma Statute. So I'll end with the talk of talking started because the talk started about the talks. We now hear a lot about reconstruction, and these talks. Knowing that we all know that it's the crimes are still being committed and justice has not been served, and we still have a long way to go. So. We all need to be very, very careful with this regard. We all need to advocate against money being given to the Syrian regime, who is the first and main perpetrator of crimes of forced disappearance, torture in detention centers, and all other war crimes and crimes against humanity. And the other thing is, within international law, there's because now companies are going to invest in Syria, and they're going to they want to rebuild Syria, of course, for money. But in international law, we can do something about it. Like companies that want to have deals with the regime, we have tools against them. Like I'm going to give an example. There's a French company called Cosmos, and this company sold surveillance tools to the Syrian regime. And for this company, it did not do anything illegal. But because these surveillance tools were used by the Syrian regime to crack on activists and eventually put these activists in detention centers and torture them, do all the things that we know. So this company is now being persecuted against in France, again under the universal jurisdiction option. And this I think is a very important tool that we have is the fact that companies can be persecuted because of their complicity in war crimes and crimes against humanity, and Cosmos is one of these examples. And another example is Lavarge. Lavarge is the company that were paying a lot of money for access, whatever. But so we have this option as well.
Does that apply to the Chinese and the Russian companies as well?
We have, it depends on the company, but of course, complicity in war crimes and crimes against humanity, it can be proved within the business and human rights under international law. So if I'm a company and I'm even selling desks, it's nothing. But these desks are being used in detention centers. Even if I don't know that these desks will be used in detention centers, I can be complicit in international crimes. So we have tools against these companies that want to deal with the Syrian regime and want to invest and make money out of our misery, basically. So I'm happy to answer any questions if you have. Thank you so much.